Senator Scarr.
Thank you, Madam Acting Deputy President. And as is usual, I can't resist but to compliment Senator McCarthy on her contribution. I can't imagine how proud those elders would be of you, and especially the way you conduct yourself, as I've commented in the past. I think as we go on this pathway towards the referendum, if all Australians conducted themselves with your tone and temperament, that would be a wonderful thing. Madam Acting Deputy President, I stand up for the people of Ipswich today, once again, in relation to the new Chum Landfill site, which is operated by Cleanaway, an ASX-listed company. Now, I gave a speech last September in relation to the horrific ordeal so many people in the Ipswich region were battling with the odour that was emanating from this landfill site. It was disgraceful, absolutely disgraceful. And can you imagine, it was so bad that residents could not even leave their homes at certain times. They'd do the washing and have to go out, get the washing and redo the washing. That's how bad it was. And what triggered my contribution in the Senate at that time was the fact that Cleanaway gave all of the senior executives 100% of the incentive attributed to environmental performance at a time when there were thousands of odour complaints. Absolutely unbelievable. Hard, difficult to fathom. Now, what's happened since then? Well, the first thing that happened is that the shareholders of Cleanaway registered their dissatisfaction and voted against the remuneration report. So Cleanaway got their first strike on the remuneration report. That's the first thing that happened. The second thing that happened is that Cleanaway is now subject to charges which have been brought by the Department of Environment and Science in relation to those matters which I discussed in this place. And these are serious charges. One offence contrary to section 441 of the Environmental Protection Act, one offence contrary to 432 of the EP Act, 10 offences contrary to section 433 of the EP Act for contravening a condition of an EA, and the prospective penalties are millions of dollars. And those charges were brought in March 2023. Now, the third thing that has happened is the Department, I should say the Court of Planning and Environment, has brought down its decision just yesterday in relation to Cleanaway's application to actually expand their activities on that new Chum landfill site. So at a time when you'd think that their focus would be on remediation, rectification and an orderly shutdown, Cleanaway was actually progressing an application to expand their operations on that site. And I made the point that in the annual report Cleanaway had issued, they made an assumption. They made an assumption that they were going to be successful in the court case. And at the time, I called that a courageous assumption. And it actually surprised me as someone who used to be a company secretary of an ASX-listed company. Well, guess what? They weren't successful. They weren't successful. And the Planning and Environment Court of Queensland has now brought down its judgment. And I call upon all of the directors of Cleanaway to reflect on that judgment. Don't just read a summary. Don't just read a summary. I call on the directors, you read the judgment that was brought down by His Honour George Michael Williamson, KC. You read the whole judgment and then you decide whether or not you're going to seek to appeal this judgment. Because what happened in this case was the Planning and Environment Court of Queensland upheld the decision of Ipswich City Council to knock back this expansion of activities on this landfill site. So the Court of Planning and Environment knocked back the application to expand the facilities on that new Chum site. And I just want to read the findings. And again, this is something the Board of Directors of Cleanaway need to reflect upon when deciding whether or not they're going to take this to the next level and appeal. So let me read these findings. In relation to environmental risk of expanding the activities, this is what the court found. I am not satisfied the evidence demonstrates the environmental risk associated with the proposed development is acceptable. So the judge, after listening to expert witnesses, considering hundreds and hundreds of pages of expert reports, this judge found that he was not satisfied that the environmental risk associated with the proposed development is acceptable. Secondly, he was not satisfied that the evidence demonstrates the conditions imposed on any approval for the proposed development can be implemented and maintained to manage environmental risk at any acceptable level. So the judge actually found that, notwithstanding what was put forward as mitigating factors and processes, etc., the judge was not satisfied that the environmental risk could be sufficiently mitigated. And then secondly, that's the environmental risk. The other risk is the risk of amenity. Now, amenity, what does amenity mean? Amenity means families living in proximity to this landfill site, going about their day-to-day business and having a look at this mound of landfill every day of the week, 24/7. That's what amenity risk is. And this is what the judge said with respect to amenity risk. It has not been established the proposed development can successfully manage its impacts on residential amenity. So you've got the environmental risk and you've got the residential amenity risk. And with respect to that amenity risk, the judge said, first, an approval would delay the rehabilitation of the land and lead to an adverse visual impact, albeit of a limited and uncertain duration. This delay is the direct product of the vertical extension. That means they're building the landfill up. It's vertical extension, it's going higher. Proposed the landfill facility, which the evidence does not establish is required to rehabilitate the land, and B, establishes will cause the facility to become more visible. And second, given the nature of the use, a waste facility, and given the circumstances traversed earlier in the judgment, an approval would be inconsistent with a reasonable community expectation. Inconsistent with a reasonable community expectation. And it's because of that community expectation that Ipswich City Council, in part, made the original decision to knock back the development application and has had to fight to defend its decision. Millions and millions of ratepayers' dollars, being spent to try and defeat Cleanaway's, and they were successful, application to overturn that original decision. The Board of Directors of Cleanaway need to reflect very, very deeply on their next steps. And I asked them, given what this judge has found, and I should say this judge is not just a lawyer, he also had a professional qualification in quantity surveying. So he was well and truly across the expert evidence. But I say to the Board of Cleanaway, given what the judge has found over days and days of hearings in a 100-page judgment, how could the Board of Cleanaway possibly sign off on this development? How could you possibly apply the precautionary principle and decide that it's the right thing to do to proceed with this development application? You couldn't. You couldn't. And that is no reflection on the employees of Cleanaway or the managers, senior executives, many of whom joined Cleanaway after the event, and certainly in terms of my interaction with the senior executives at Cleanaway on this matter, they've been very courteous, from my perspective, engaged in good faith in terms of communication. But this is about management of environmental risk and risk to amenity. And the judge has been very, very clear on both counts that because of the nature of the site, which is outside of Cleanaway's control, but because of both the nature of the site and the nature of the risk, you simply cannot sign off on this development from an environmental risk perspective or an amenity perspective. I say to the Board of Cleanaway, given what's in this judgment, read the judgment. Read the judgment. Don't read a summary of it. Read the judgment. And if you read the judgment, you could not possibly come to a conclusion that this development should proceed. Now is the time for Cleanaway to bring this sad and sorry saga to an end, to remediate the site, to consider its legacy and to end this misery for the people of Ipswich.